Buenos días también por mi parte. Gracias a todos por su interés en nuestro observatorio y, como ya se ha dicho, empezamos directamente con la sesión del trabajo para poder disfrutar hoy de manera máxima esta mañana. Tengo el placer de presentar la sesión en la que se va a hablar del caso de Alemania y el caso de Suiza. Ambos países han tenido un largo periodo de reformas, digamos desde los años 90 hasta la década pasada, y los resultados de las reformas son a lo mejor conocidos por su parte, pero ya después de los primeros años en vigor de las reformas, podemos ver ahora un poco cómo se ha implementado, digamos, esas nuevas regulaciones, y también qué son luego las consecuencias y si ya realmente se debe plantearse nuevas reformas o nuevos debates al respecto sobre la reforma sobre el federalismo alemán o el federalismo suizo. Al principio va a hablar el profesor Wolfgang Rentsch sobre la regionalización de la formación de preferencias en estados federales y descentralizados. En el caso alemán, eso es un proyecto de investigación financiado por el gobierno alemán, y él tiene, digamos, el subtítulo de este título: del Estado unitario al federalismo competitivo. Eso es una nueva tendencia que ha detectado, y estamos ya también muy interesados en escuchar su experiencia. El profesor Wolfgang Rentsch es profesor de la Universidad de Magdeburgo y ahí director del Departamento de Ciencias Políticas y tiene la cátedra Jean Monnet de Estudios Europeos. Sus principales ámbitos de investigación son instituciones y las estructuras de trabajo del sistema alemán de gobierno, la integración europea y la comparación de los sistemas de gobierno. También ha trabajado mucho, también su tesis doctoral versó sobre políticas fiscales y compensación financiera, un tema que a lo mejor luego también está abierto a preguntas después de su intervención. Por supuesto, tiene numerosas publicaciones relativas al federalismo alemán y trabaja muy estrechamente tanto con el gobierno de Sachsen-Anhalt también como experto para el gobierno federal. Profesor Rentsch, tiene la palabra.
Gracias. Yes, well, thank you, Mario. I will speak in English because my Spanish, I understand a little bit, and I can say gracias, but not much more. So therefore, I hope you will know. Therefore, I will speak in English. Well, the general topic has been announced by Mario already, and the main topic is the changes of German federalism since unification, the process of reforms which we had there. And the main paradigm is a change from a kind of unitary federalism towards competitive federalism. Well, the discussion about federalism in Germany has a long tradition as on the academic as well as on the political agenda. The debate started already a long time before 1990 when Germany was unified, but continued afterwards with much more intensity. The Unification Treaty of the 31st of August 1999 stipulated that the legislature of the Federal Republic should revise the relation between the federal and the Länder governments. This provision initiated a federal reform process which will last probably until the year 2019 for several more years, and then this process will have taken 30 years. But that is I'm not quite sure whether we will really at the end in the year 2020. The result will be, if the process will be finally successful, what we all hope for, a thorough overhaul of the German federal system. The imperatives of this process were first to make the German federal order fit for the ongoing process of European integration. We expected once to have a European constitution in 2004. You might remember that. And as the second issue is to adapt the federal order to an enlarged, however much more inhomogeneous Germany, having now 16 Länder instead 11 before. I will not go into details, and that would be rather boring, of this endeavor, but explain the structures of this process. The first small federal reform of the federal system changed just the general objectives. In 1994, the Article 72 of the Basic Law was amended. The new version stipulated that the Federation may use its concurrent legislative powers only if it was necessary for equal living condition or the protection of the legal and economic unity of the country. Before this amendment, the Federation could apply its concurrent legislative powers when it considered the use as appropriate for uniform living conditions. So, from a necessity to appropriateness and from equal to uniform, it's quite a difference, you know. And it took about 10 years until the Federal Constitutional Court made use out of this new phrasing and stopped, you know, the ongoing centralization of legislation. So, parallel to this first process of constitutional adaptation, a second working group developed an amendment to reform the system of intergovernmental fiscal relations in order to integrate the East German Länder into the existing equalization system. Here I will go also not into details, but I will come back to this topic later. Due to the proceedings at the Federal Constitutional Court because of the plea filed by the Länder Baden-Württemberg, Bavaria and Hessen, the debate about the federal reform came to a halt because the players in the game waited for the rulings of the court. Despite the proceedings of the court, the new red-green government elected in 1998, yes, under Chancellor Gerhard Schröder, placed the federal reform on the reform agenda again. However, it took until the October 2003 when a joint commission for modernization of the federal order was called. This commission was supposed to review the allocation of legislative powers to the federal and the Länder levels. The powers and rights of co-determination of the Länder government in federal legislation and the intergovernmental fiscal relations, in particular the joint task and the sharing of expenditure between the federal and the Länder government. Also, the consequences of European integration should be taken into account. It was quite a vast program, and the Commission did not handle all this question because it was too much. But the result of this commission contributed to a clearer delimitation of the legislative powers of both levels of government. In particular, the constitutional legislator amended the Europe Article 23 in the Basic Law, which allows the Federal Republic to be presented by a Land Cabinet member in the Council of Ministers of the European Union in matters of primary and secondary education, culture, or broadcasting. So there are certain instances in which the Federal Republic of Germany is represented in Brussels at the Council of Ministers by a member of a land government, not by the federal government. It allows the Länder legislatures to deviate from federal legislations in 6 areas of the concurrent legislation, so that the Länder law overrides in this 6 areas the federal legislation. And also it provided new exclusive legislative powers for the Federation in 5 policy areas. So that what we had is that certain policy fields which were in which we had joint decision-making process were given either to the Länder or to the Federation. And this commission, the results also strengthens the powers of the land parliaments by transferring the legislative powers in 6 policies from the Federation to the Länder. Also, it abolished the framework legislation of the Federation, and it changed the rights of the Länder in implementing federal laws and the role of the Bundesrat. In those cases in which the Länder administrations implement a federal law, their parliaments were entitled to deviate from federal administrative bylaws unless the federal law ruled otherwise. In those areas in which the Länder were allowed to deviate from federal regulation, the federal law does not need the consent of the Bundesrat any longer, which also makes decision processes easier. Finally, it deleted the construction of universities from the list of the joint parks, introduced a new clause ruling that the federal law needs the consent of the Bundesrat, that is in the other direction, if it obliged the lender to provide financial assistance. And also it allowed the lender parliaments to set the rates for the tax on the purchase of real estate. Taking in account the amount of change of the basic law, it is justified to speak of the most extensive reform of the Constitution since 1969. However, the core issue of any federal order, the intergovernmental fiscal relations, remained untouched except a few marginal amendments. These issues were the leftovers for the next reform. Because of these leftovers, the Second Reform Commission was called in December 2006, which had taken over the task to develop proposals for the modernization of the system of intergovernmental fiscal relation. The second, the official counting is the second, in fact it's the third Reform Commission, if you take the small reform into account of 1994. The constitutional reform of 2009, which was the result of the Second Reform Commission, primarily allowed the evaluation of performance and benchmarking of public administrations. That's something very new in Germany, that now the public administrations compete and they will be benchmarked. And secondly, allowed the federal government to provide financial assistance for the lender in cases of natural catastrophes and extraordinary emergency situations which cannot be controlled by the government. Where there always was a question, what kind of a catastrophe must it be if it can be controlled by the government? So, and last not least, and probably most important, the compromise introduced the debt brake in Germany. Again, key questions of the system of intergovernmental fiscal relations were not answered. In particular, the Commission did not address neither the issue of tax legislation by the lender, nor the distribution of revenues between the Federation and the lender, nor the problems of fiscal equalization among the lender. The latter issue was left for the future negotiation, which have to be finalized until the end of the year 2019, the year I mentioned before. And the main problems for the reform we need to have in 2019 will be the different burdens of the lender caused by federal legislation, budgetary effects of domestic migration and demographic change, and the debts of overburdened lender, tax legislation by the lender, incentives within the equalization system. So that is a big enough agenda for 2019. So, now, having explained this general framework, I would like to raise the question of what has been achieved by these two reforms we have already adopted. These two parts of the still unfinished federal reform process have not completely implemented yet, just about 5, respectively 2 years after they had been adopted. An assessment of their effects with respect to new developments within the federal systems turn out to be a rather challenging task. Certainly, it is far too early to draw final conclusions. Therefore, the following explanations have to be limited to preliminary remarks on a few aspects of the reforms. They focus on how the lender have used their new powers and how governments have anticipated the debt brake. But let me start with a more general remark. Let's say in 50 years from now, historians might look at the developments between 2002 and 2020, or even between 1990 and 2020, as a long process of constitutional adaptation of the old West German Federal Republic to the challenges of German unification and European integration. This process has followed a logic determined by the Basic Law. Its general leitmotif can be defined as strengthening the accountability of all levels of government. Even the small reform of 1994 introduced a change of paradigm in German federalism going in this direction. The permanently increased precedence of federal legislation as well as joint decision-making were questioned and revised. The 2006 reform follows this change of paradigm and tried to disentangle joint federal Länder decision-making in legislation and to separate the jurisdictions of the Federation and the Länder. This separation of powers was pursued not only with respect to legislative matters, but also and primarily in the area of administration. Part of this was the rule that the Federal Republic shall be represented in the Council of Ministers of the EU by a member of the Bundesrat, of the Länder side, in cases when issues of exclusive land legislation will be on the European agenda. After the reallocation of powers, the next step aimed at the budget. The 2009 reform amended the Keynesian budgetary principles introduced in 1969. The target was the achievement of an overall economic balance, and introduced new criteria based on Article 104 of the treaty establishing the European Union, respectively Article 126 of the Treaty on the Functioning of the European Union. In principle, the budgets of the Federation and the Länder should be balanced without debts. Exceptions have been limited to deficit spending in recession, natural disasters, and emergency situations beyond government control. Governments borrowing money, oops, that was too fast. Governments borrowing money have to provide a repayment scheme for the debts. This regulation did not abolish the Keynesian principles of budgeting, but much more introduced the omitted part of Keynes. In periods of economic growth, debts have to be paid back, what never happened until now. What effects can now be measured until today? The first point I would like to make is the limiting of the joint decision-making of the Bundestag and Bundesrat. Whether the attempt to disentangle joint decision by the two chambers of the federal legislature was successful or not has been a matter of dispute. Here, as often, we can say it depends. It depends on the yardstick. When you take all federal laws into account, the effect is considerably small. However, when you take just those laws into account which are suitable for decision-making by the Bundestag alone, then the assessment will be different. The transformation of European law regulations into federal law, into German federal law, needs the approval of the Bundesrat as long as the implementation remains the task of the Länder, and the European law does not allow the deviation from the law. Also, all federal laws which have an effect on the tax income or the financial burdens carried by the Länder cannot be disentangled. Also, constitutional amendments require the consent of the Bundesrat. When we omit those federal laws which need the consent of the Bundesrat because of constitutional reasons, roughly 40%, look at the laws which require the consent of the Bundesrat because of administrative procedures adopted by the Länder, the other, roughly 60%, then the effect of the reform is really considerable. Of these 60%, about 3/4 concern transformation of international or European law into German. In these matters, the federal legislation is not in the position to allow the Länder deviating administrative bylaws. As a consequence, it is next to impossible to relinquish the consent of the Bundesrat. The remaining part was large enough to let the proportion of the consent requiring laws drop from 57% to 43% within 2 legislative periods. That might not be a radical reform, but it is quite an effective one, I would say. One of the political effects will be that under the condition of a divided government, a federal opposition party, when it commands a majority in the Bundesrat, will have less chances to compel a ruling majority of the Bundesrat into bargaining process on legislation. The next point I would like to look at is the use of new legislative powers by the Länder governments. How do the Länder use their new powers? The new legislative powers concern primarily the regulation of public houses, question of smoking, non-smoking in pubs, shop closing time, tax rates on the trade of real estate, salaries of the civil servants, sheltered homes, and the prison regime. Taking into account the current practice of the lender, two different approaches can be distinguished. Individual lawmaking by which each land does it my way, for instance in the field of local equalization, and coordinated lender laws negotiated on what we call the third level among the land administrations. For instance, we have that since decades in the police law. Police law is a matter of lender legislation. However, we have 16 lender police laws which are all the same. That is coordinated among the lender governments. Also, we have to distinguish between policy areas where no federal law existed before and land legislation in which the lender got or had taken over the power of legislation from the federation and in which we have still former federal law. The lender governments have used their new legislative powers received by the 2006 constitutional reform in at least 6 cases for autonomous land legislation. Concerning non-smokers' protection in public houses, there was no former federal law which could have been given an orientation. In this case, all lenders, meanwhile, have adopted varying regulations. Passed by a successful referendum, the Bavarian law implies the strictest rule, generally prohibiting smoking in public houses at all, including festival halls and tents. The other lenders provide more or less extensive exceptions for non-smoking roads. Hamburg, Lower Saxony allows smoking in small pubs. However, Hamburg and Lower Saxony only if no hot food is served. Baden-Württemberg allows smoking in pavilions on fairs, festival halls or tents only. Berlin allows smoker pubs and smoking in separated rooms. Brandenburg also allows smokers pub, but not in separated rooms, while Bremen allows smoking in separated rooms. Most lenders allow smoking in separate rooms, however, under varying conditions. For instance, in Saxony-Anhalt requests that guests must be able to have access without passing through the smoker's room or should not be molested when using the lavatory. So that is, despite the fact that there had been a federal law before, the regulations of the shop closing time varies considerably among the lenders too. 10 out of 16 lenders allow shopping from Monday until Saturday all day and all night long. 4 lenders restricted the opening hours on these days to 6 a.m. to 10 p.m. respectively. 2 lenders require different closing hours on Saturdays, namely 8 p.m. or 10 p.m. respectively, instead of midnight. Baden-Württemberg, which allows shopping on 6 days a week all day long, restricts the selling of alcohol to the time from 5 p.m. to 10 p.m. So Sunday regulation shows slight differences only. 11 lenders apply the old federal law, permitting 4 Sundays per year shops to be open. Other lenders are more liberal. Brandenburg allows 6, Berlin 8 open Sundays. In accordance with the old federal law, all lenders allow shopping at gas stations, airports, or railway stations any time. Officially, these shops are for travel necessities only. In reality, they have become more or less shopping malls for all kinds of goods. So, compared to the federal law on shop closing time of 2003, that was the old federal law, the land legislation have led to a liberalization of the former regulations. In particular, the new land laws pay respect to local particularities and interests. For instance, the mainly Catholic lender Bavaria and Saarland allow Sunday shopping after the main Sunday church service has taken place. That's in the law. Berlin was interested in long shopping hours also on Sunday because the city government forbade tourists, but the federal constitutional court forbade that. And finally, we have quite an interesting competition among the 2 lenders at the Baltic coast, which strive for opening the shops on Sundays during the tourist season. In contrast to that, the different tax rates on the trade of real estate introduced by the Länder are hardly more than a variation of the federal law. The federal law sets the tax rate at 3.5% of the price. The Länder are now entitled to change this rate. The revenues achieved by the rates above, also below, the federal rate will not be taken into account in the fiscal equalization scheme. Therefore, higher rates provide real money for the coffers of the Länder. So far, 8 Länder have used their right to raise these taxes. They apply now rates of 4% to 4.5 or even 5%. I think the other Länder will probably follow. But what we can see here is that the economically weaker Länder were the forerunners in raising these taxes. The 2006 reform also introduced competitive elements regarding the salaries for the civil servants. Even though the salaries of the civil servants were fixed before 2006 by federal law, competition in this field existed already to a certain extent. The structure of staff positions in the public administration varied from land to land, also did the career prospects. On the other hand, in 2010, most of the Länder followed the decision of the federal government to increase the payments despite their new powers. The government of Baden-Württemberg, facing land elections, and the government of Bavaria considered higher increases for their civil servants. Most of the poor Länder have reduced or cancelled the annual remunerations, the so-called Christmas bonuses, which, however, the Länder could also do before the reform took place. The legislation on homes is not finished yet. It addresses the regulations of nursing homes for the elderly and handicapped people who need constant care. Here again, we observe a variety of approaches. 2 Länder, Hessen and Thüringen, have not yet come up with their own legislation and thus continue to follow the regulation of the still existing federal law. The other Länder all went their own way, as even the titles of the laws indicate. Home law in Baden-Württemberg, habitation and participation law, North Rhine-Westphalia, nursing and quality of habitation law in Bavaria, law concerning the habitation, care and nursing quality for the elderly as well as for persons in need of care and handicapped adults, and so on. Here we see the smaller the land, the longer the title of the law. That is the small Länder show their importance by the long titles, which are very difficult to translate. But one of the most interesting cases, and the last case I will introduce here, is the case of the regulation of the prison regimes, in particular for juvenile offenders. In 2006, the Constitutional Court requested a law regulating the penal system for the juveniles. The lack of a legal regulation in this field did not comply with the basic law, since any encroachment on the basic rights of a citizen needs a firm legal foundation in a formal law. After the 2006 federal reform, this task had to be by the Länder, not by the federal government. And therefore, the Länder had to pass their own laws without being able to copy more or less an existing federal law. However, this case is a good example for the unintended effects of the separations of powers between the federal and the land level. It reveals how decentralization might cause new entanglements and new joint decision also now horizontally among the Länder governments instead vertically between the levels. The Länder pursued different ways to solve this problem. 13 of them adopted laws for the detention of juvenile delinquents. 3 did not create separate laws, but integrated special rules for adolescents in the general laws regulating the penal system. 10 out of the mentioned 13 Länders agreed on a common regulation for adolescents, again the third level of coordination among the Länder. The 4 Länder passed new penal laws regulating the imprisonments of juveniles and adults. The remaining Länder continue to apply the still existing law for adults. So, the difficulties for autonomous land legislation arise from 2 circumstances which actually restrict the discretion of the Länder parliaments. Firstly, The legal procedures, as well as the organization of the penal courts, are still regulated by federal law, limiting the land powers. Secondly, the detention of convicts can be considered as a cross-border issue, especially for the small lender. Here, three aspects have to be taken into account. First, prison inmates should serve their sentence as close to their homes as possible in order to promote social integration after their discharge from prison, independent whether the crime has taken place or whether the convict has been sentenced. Secondly, not all lenders provide all kinds of prisons, like, for instance, for women or for high security delinquents. Thirdly, not all prisoners comply with the prison rules. When prisoners show deviant behavior or got involved in forbidden activities, for instance, drug trafficking in the prison, they have to be taken out of their networks and be transferred to other prisons for security reasons. These requirements provide problems for the small lender, maintaining only 1 or 2 prisons on average. Furthermore, some lenders cooperate in implementation of the penal system. The government of Saxony-Anhalt, for instance, refers female convicts to Saxony. Berlin is constructing a new prison in Brandenburg on the soil of an entirely different land. Currently, Berlin transfers inmates of prisons to Brandenburg because the Berlin prisons are overcrowded and those in Brandenburg offer empty places. There was once a German movie, Im Kittchen ist ein Zimmer frei. In the prison, there are vacancies, you know. Therefore, the issue of regulating the prison system is not only a question of the political philosophy regarding whether a land puts more emphasis on the deterrence of would-be criminals or on social reintegration of the convicts after leaving jail. It is also a question of which law applies for which person. If somebody has been sentenced in one land and has to serve his or her sentence involuntarily in another land, it has to be decided which law would apply. In the case of the law of the land X provides more rights than that of the land Y. For instance, a prison inmate may request the rights he or she would have at their place of residence or of their place of convictions. According to experts, these questions remain completely open and nobody knows yet how the courts will decide. These uncertainties of cross-border issues due to diverging land law instead of a uniform federal law particularly induces a small lender to coordinate their legislation. Experts still disagree whether or not coordinated land legislation provides better solutions compared to federal solutions. To sum up, the legislative activities of the lender in the areas of decentralized powers prove that they have used their new competency in rather a pragmatic way. In particular, mostly economic or financial interests of a land play a more important role than ideologies or party interest. Concerning non-smokers' protection, legislators tried to balance concern of smokers and non-smokers alike, independent of parties or in the parliament. Concerning shop closing times, lenders with predominantly Catholic population have been more restrictive and Sundays were concerned. Besides that, the tourist industry and their interests have influenced the land legislation on this matter. Variation in tax policies and remunerations of civil servants reflect the financial situation of the lender. As a consequence, the new land laws in general did not reveal radical changes or partisan policies, but aim at the incremental adaptation to local circumstances. Yes, finally, the debt brake. The debt brake introduced in 2009 will show its full effect for the federal level in 2016 and for the lender in 2020. However, already now governments of both levels have to anticipate the rules. The federal government aims to balance the budgets in 2014 and the lender tries to get along without debts in 2012. A few of them have avoided new deficits even before the financial crisis, but could not compensate the decline of tax revenue during the crisis by regular budgetary matters. All the three lenders, meanwhile, have introduced the debt brake in their land constitutions. In principle, these lenders have adopted the federal regulations. Others will fellow. So we will see what will be the result of the whole process, but I have the impression that meanwhile, politics started to understand what the debt brake mean. You can see that, for instance, in North Rhine-Westphalia, when the new government firstly started in the traditional way of budgeting, but meanwhile the Constitutional Court of North Rhine-Westphalia has stopped the government and has requested lower debts. Well, let me conclude. Certainly, it is not difficult to argue that the reforms of German federalism did not meet the ambitious aim and that a better solution could have been possible in one or the other issue. However, that would immediately provoke a dispute about what is a better solution. In political practice, the second best solution, based on a broad consensus, might often be preferable. Moreover, if we consider the evolution of German federalism, driven by a series of constitutional reforms, it is fair to conclude that the results achieved since German unification are quite remarkable. Well, the process of modernization of the federal order has not come to an end. The reforms of 2006 and 2009 only mark steps in between. The probably most difficult task, the review and reform of the intergovernmental relations, are still on the agenda. And the discussion about that has started yet, and we will see how that will end. Thank you for your attention.